we can start our morning session now. We are very happy to have two speakers this morning. We're going to start with Elena ARDITO. She's a postdoctorate fellow at the University of Macerata in Italy. And she's going to talk about the continuity of statehood and human rights protection of forcibly displaced people, and the case of Tuvalu in the light of the Palepeti Union Treaty. So it's one aspect of climate change and law of the sea, which is very topical. And afterwards, we're going to hear Ana Pedrajas. She's a doctorate PhD student at the university here in Lyon 3. And she's going to talk about the international law and cultural heritage law, the link between both in French, but I'm continuing in English. And afterwards, we're going to have a discussion about those two aspects of law of the sea and climate change. So I'm not going to talk more, but we are going to have the discussion after. So Elena, you can start. Thank you very much.
Okay. Good morning, everyone. Thank you for this presentation. First of all, I would like to thank very much the Professor NERI and RICARD for this invitation, because it's a big pleasure and honor for me to be here and to participate in this discussion. And so, as you can see from the title of my presentation, today I will talk about the theme of sinking states, and I will talk about the questions that this theme raise under international law, that is continuity of statehood and protection of people affected by sea level rise. And I will take into consideration, in particular, the case of Tuvalu and the Palepeti Union Treaty, that is an agreement signed by Tuvalu and Australia on November 2023. And just to give a brief context, I understand that after this image, probably all of us would like to be there, but we are here. And so Tuvalu fits perfectly in the definition of a sinking state, because it's a country, it's an island country in the Pacific, really small country with a total area of only 26 square kilometers and around 11,000 citizens. It consists of 9 islands and a series of atolls, and many of which are barely 2 meters above the sea level. So for this reason, it's one of the most country deeply threatened by climate change and threatened by, in particular, by sea level rise. And in fact, the United Nations Development Programs estimated by 2050, half of the capital will be flooded, and that 95% of Tuvalu territory will be totally submerged by 2100. So it will be really a lost paradise, and this. And the case of Tuvalu and the case of sinking state in general raise two big topics under international law, that is the continuation of statehood. And in this case, the question is, can a state destined to have no territory at all, destined to completely lose its land as a consequence of climate change, and so as a consequence of sea level rise, continue to be considered a subject of international law, as a state under international law? And the other main topic is the so-called human phase of sea level rise, that is, what is the protection that international law offer to people affected by sea level rise, that fall into the still precarious definition of climate migrants. And first of all, for what concerns the continuity of statehood, now there are two opposite theses on this theme. The first one we can call the austere view, that is based on a strict and literal interpretation of the requirements established by the Article 1 of the Montevideo Convention. And so, according to this strict and literal interpretation, if a state loses one of these requirements, that is, in the case of sinking state, the land, the territory, it necessarily ceases to be a state and cannot be considered anymore a subject of international law. And this thesis is supported by a number of scholars and also by some states. And in this sense, we can see the submissions by United Kingdom and Germany to the last session of the International Law Commission in relation to the topic of sea level rise. On the other side, we have the flexible thesis, the flexible view, according to which the Montevideo criteria should allow a certain degree of flexibility. So, according to this thesis, the statute of sinking state will continue, notwithstanding the partial or total disappearance of the lands due to climate change and in particular due to sea level rise. And this thesis is supported by much of the doctrine and by the currently by the majority of states participating to the work of the International Law Commission in relation to the topic of the sea level rise. And in this regard, it's particularly important, it was particularly important, the US government declaration of September 2023, and also the declaration adopted by the leaders of the state, countries, and territories of the Pacific Islands Forum of November 2023. And what are the reasons of this flexible view? First of all, according to this thesis, the Montevideo criteria refers to the first acquisition of statehood and not to the maintenance of it. So they are necessary to a state to begin to exist. But once a state exists, it benefits from a presumption of continuity, even if one or more of these requirements, that in this case is the territory, diminish, or in the most critical circumstances do not exist at all. And there are also positive precedents in international, in state practice. There are already examples in international law that demonstrate that that this requirement can be interpreted in a more flexible and nuanced manner, like the case, and I refer to the case of governments in exile and the case of deterritorialized states like the Holy See and the Sovereign Order of Malta. And another point is that this flexible view guarantees the stability of the international relations. And it guarantees also the stability of citizenship, because according to some scholars, it's more a practical question than a theoretical one, because the austere view as the risk implies the risk that the citizens of the so-called sinking state can become effectively stateless. So this is another point. And it's a view also compatible with the principle of self-determination, because the continuity of statehood let sinking state citizens maintain their nationality, but also to maintain their ancestral bond to their land and their relation to the country of origin. So there are also evident implication on identity and on cultural rights of people. And last point, the loss of statehood of sinking state due to sea level rise would represent an unfair and unequitable outcome, because the consequences of a global phenomenon, that is climate change in general and in particular of sea level rise, will be reflected on those international actors that in this case are sinking state, which in most cases are small island and developing countries that have contributed in a very minimal way to the causation of the problem itself, to the causation of climate change phenomenon generally considered. And For what concerns the other topic, that is the protection, that is also under discussion in the International Law Commission work in relation to the topic of sea level rise, that is the protection of people affected by climate change and by sea level rise in particular. So in this case, the starting point is that there is an international law lacuna concerning the protection of people forced to migrate as a consequence of climate change, as a consequence of sea level rise. So now there's no binding international law instrument specifically dedicated to this topic, and so there is no dedicated legal framework or distinct legal statute for what we call, for the category that we call climate migrants, that is still on definition in reality. And so, what protection for these people? It's necessary to explore and map the hard law and soft law instrument that can be applicable to these people, even if they are not specifically dedicated to them. And what are the the legal frameworks explored in this sense? First of all, the international human rights law that can be considered a common framework to govern the matter through obviously an evolutionary interpretation of the provision concerned, of the provision of the international human rights law treaties and conventions. And there are lots of human rights that might be threatened or affected by sea level rise, like the right to life, the prohibition of inhuman and degraded treatment, the right to housing, the right to food, and etc. And another question is, who is the responsible state in this regard? According to a general rule, the principle is that states have a primary responsibility to provide protection and assistance to people that are residing in their territories and or are under their jurisdiction. And so this is a general rule of international human rights law that applies also to the case of people affected by sea level rise. And there is also a declaration in this sense. This is the Sydney Declaration of 2018. And so, in the context of in the context of sea level rise, there is obviously a human mobility. So, when people remain affected by sea level rise, but remain in the territory of the state affected by climate change, we can say that the responsibility is on the country of origin. But when the people move, the responsibility could arise also in relation to the state of destination. And what are the duties involved? For what concern the country of origins, we have to say that all this duty has to be considered in line with the real possibility, financial possibility and resources of the state concerned. And the duties involved in relation to the country of origin are the duty to prevent and mitigate natural disasters, and in this sense, the measure required can include the reduction of greenhouse gas emissions, the plans for crop diversification, water desalinization program, etc. And also, there is also a duty to promptly act to save people when a natural disaster occur or are about to occur. And in this sense, the measure required could be evacuation measures, relocation plans to avoid the effect of natural disaster in general. And in this regard, there can be a possible tension between the local communities' right to remain, right to stay in their territory with which they have an ancestral bond, and the state duty to protect people's lives, and so to relocate people to other places. And there is an interesting decision by the Human Rights Committee in this related to this topic, that is Billion Dollars versus Australia of September 2022, in which Australia has been condemned by to redress a group of Australian citizens living in the Torres Strait Island because of its failure to put in place, to implement in an effective and in a prompt way mitigation and adaptation measures. And so this failure led to the relocation of these people. And this decision by Australia has been considered as a violation of cultural rights and of right and the family rights of this group of citizens. And for what concerns the country of destination, well, we all know that the historical decision Taitiota versus New Zealand of 2019 it was not a positive decision, not a successful decision, but it established the principle that the principle of non-refoulement could be triggered also in relation to climate change cases, to climate migration, and also it could be applicable also to sea level rise topic. In this case, the state of destination has the duty not to return the person concerned when the pushback to the country of origin implies a risk of irreparable harm, and in the irreparable harm in the context of sea level rise could be the deprivation of a series of basic rights, which will determine the impossibility to conduct a decent life and a life with dignity. And another framework that could be explored to consider the protection of people affected by sea level rise is international refugee law. But in this case, we have a general rule that is that the definition that in generally speaking, the definition of refugee under Geneva Convention is not applicable to people affected by sea level rise, so by climate change and by sea level rise. So there is so also the common expression climate refugee is a misleading term because this category basically generally that does not exist, but in some exceptional cases when we consider the context in which sea level rise occur, the effect of climate change and the effect of sea level rise read in combination with other political, social, and economic factors can determine the fulfillment of the requirements of the Geneva Convention, of the requirement of the Geneva Convention, and so only in this case the refugee status can be granted. Also, in relation to the protection of these people, we can see that what is going on in the state practice, because lots of states are elaborating and releasing humanitarian visas and permits specifically dedicated to people affected by climate change and natural disasters. And also we can see that the implementation of human mobility pathways between two or more than two countries, and there are also lots of regional instruments or programs that are in development. And this is the context in which the Philippine Treaty could be framed. And this is a bilateral treaty between Australia and Tuvalu, signed on 9 November 2023. Then on May 2024, it was signed an explanatory memorandum that is an important interpretation tool of the treaty. And then the treaty entered into force in August 2024. And why the name Falepili? The treaty is inspired by the traditional Tuvaluan concept of Falepili, which means good neighborness, duty of care, and mutual respect. And the main purposes of the treaty is to elevate the relationship between the two parties, but most important, it provides citizens of Tuvalu with a special mobility pathway to access Australia, and on the other side, another purpose is to protect and promote each party's collective security and sovereignty. For what concerns the human mobility pathway, it's important to know that, that under the treaty, the parties recognize the desire of Tuvalu's people to continue to live in their territory where possible, and Tuvalu's deep ancestral connection to land and sea. So it's an important statement because it gives us the approach of the treaty, which is the respect of the identity of Tuvaluan citizens and the respect of their right to remain as long as it's possible. And according to this treaty, the citizens of Tuvalu will have the possibility to access Australia and to live, study, and work in Australia, and also access Australian education, health, and key income and family support on their arrival. So we can see that that in the treaty the provision regarding the effective protection offered to Tuvaluan citizens are really vague and generic, but the explanatory memorandum signed in May 2024 clarifies a lot of points. For example, it clarifies that will be an annual allocation of 280 visas, and that this number could be adjusted year by year. And that the Falepili visa will provide for an indefinite permanent residency with freedom for unlimited travel to and from Australia. The memorandum also clarifies that the Falepili visa holders will be eligible to apply for Australian citizens, but without losing the Tuvaluan citizenship. This pathway, this mobility pathway, will be open to all Tuvaluan citizens who are at least 18 years old, and they don't have to have specific competencies or jobs, so there is a no brain drain risk. And also the pathway will be open to Tuvaluan citizens with disabilities, special need, and chronic health condition. And for what concerns the continuation of statehood, it's important that under the treaty that the party recognize that both parties recognize the statehood and sovereignty of Tuvalu will continue, notwithstanding the impact of climate change. So it will continue also when the territory of Tuvalu will totally disappear. And so there is a commitment by Australia in the recognition of statehood for now and for the future. And another important article is Article 4, which regards cooperation for security and stability, according to which Australia will provide assistance to Tuvalu in response to major natural disaster, public health emergency, and military aggression against Tuvalu. But there is all of this, so security, help and protection offered to Tuvaluan citizens at what cost? The most controversial provision of the treaty is Article 4.4, which states literally that Tuvalu shall mutually agree with Australia any partnership, arrangement, or engagement with any other state or entity on which regard security and defense-related matters. So some commentators have criticized a lot this provision, talking about a sort of veto power, an Australian veto power on Tuvalu's foreign policy. Someone talked about a neo-colonial threat and of a provision which undermines Tuvalu's independence. But we can see that first of all, the memorandum clarifies and recites this provision because it clarifies that Tuvalu does not need any authorization or any permission from Australia before it starts to talk with other partners, but it needs its authorization to sign an agreement on a defense-related matter. The memorandum also clarified that Article 4.4 does not diminish Tuvalu's standing in the global fora, and that it will not preclude any other Tuvaluan agreement with other parties that concern other matters that are not related to defense and security. So this intrusion will cover only defense-related matter. And according to the Prime Minister, the Tuvaluan Prime Minister Theo, and obviously to the Prime Minister of Australia, it has a reasonable explanation, because according to this treaty, Australia obliged itself to provide security and defense assistance to Tuvalu. So it will be in Australian interest to be informed and to have a role in any other agreements that Tuvalu could sign with other parties related that is related to defense. To defense and security, because Australia must verify if this potential other agreement will in some way compromise its ability to fulfill its obligation to provide security assistance. And there are also safety valves for both parties in the treaty, because if any party feels that if the other is not living up the spirit of the treaty, each part can open a negotiation through the joint committee established by the agreement, and temporarily suspend the compliance of one or more obligation. And there is another provision that allowed parties to terminate the agreement at any time by written notice. So there are some safety valves that could be applied also to these controversial provision. And so, in conclusion, according to my opinion, for what I've already said, so what the memorandum clarifies, the fact that this intrusion covers only defense-related matters, and considering also the safety valves provided by the agreements, in my opinion, there is no a real neo-colonial threat or a real threat to Tuvalu independence. On the other side, it's an important agreement for what concern the question of the continuation of statehood, because it's a positive state practice in this regard. And on the other side, it's a positive agreement also if we consider the protection offered by Australia to Tuvaluan citizens, because it's a broad protection. It's a protection that respects their right to remain, they respect their cultural identity. It will provide a permanent right to stay in Australia, so it's not a temporary protection but a permanent protection, and also allow Tuvaluan citizens to maintain their citizenship if they decide to apply for Australian citizens, so to maintain their nationality and their bond to their territory and to their land. So we can say that there is a human rights based approach in this regard. Obviously, it's a protection offered by Australia only towards Tuvaluan citizens. So it's not a solution of the problem, obviously, but according to me, it's a good state practice that can be seen as example for other bilateral or multilateral treaties in this regard. So thank you very much for your attention. Thank you.